Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone, and welcome to this session of the Appeals Court. My name is Amy Blake, and I am pleased today to be joined by Justice Rachel Hirschfang to my right and Justice Andrew D'Angelo to my left. We are your panel for all 5 cases today. Most of you have been here before, but to briefly go over the rules, each side is permitted 15 minutes of argument. I can assure you that we have read all your materials, so you should get to the thrust of your argument right away. There is no rebuttal. After the 3rd case, we will likely take a morning recess of about 15 minutes. And if there is nothing else, we will call the first case, Commonwealth versus Anthony Winchenbach, docket 22P 0038. Attorney Sanchez.
Good morning. May it please the court. Alicia Sanchez for the Commonwealth. This is the Commonwealth's appeal. It pertains to an allowed McCarthy motion to dismiss the indictment of misleading an officer. Our focus is on the misleading element of the charge. The issue is whether, in hiding evidence and staging the scene, all in an effort to divert attention away from him, the defendant intended to create a false misrepresentation, a false impression in the minds of the officers that he was not involved in the deaths of his fiancée, Miss Rachel Golaski, and their unborn child.
Is this because of his conduct as compared to his words?
It's actually both. It has to do with, I'd like to focus on the conduct here.
Well, let me just ask you briefly about the words, because if the police knew that what he was saying was not true as to his words, how is that misleading under the statute?
Well, we're not focusing, the statute doesn't require that we focus on the false statements here where everything began with his conduct, and the false statements later on, which could be contradicted by evidence, really showed his intent to continue misleading the police. Here, the defendant engaged in deliberate and calculated acts that were in the early stages of the investigation that did at times send the police down the wrong paths. If I could focus on this is the potential manslaughter case, and there's questions not just who's involved, but there's questions of who's the source of the drugs, who administered the drugs to Miss Golaski.
When you say it's a potential manslaughter case, at the time of the investigation, not now, he's not been indicted for manslaughter.
He has not at this time been indicted for manslaughter. But to be clear, a defendant can mislead the police in an investigation before that investigation even begins. And so just to focus on the 3 acts that happened in the hotel room. First, the defendant hid evidence in a trash can and then ultimately moved that under the spare tire of Miss Golaski's car. Then he after having removed all that evidence, left 1 needle next to Miss Golaski's body. And then knowing that she was deceased, called her phone and texted her, "I love you, I'm going out fishing." I want to focus on, while all these acts are misleading, the act of moving the bagged evidence into the trash can led the police down the wrong path at a point where, after having, in that early stage of the investigation, they eventually watched the surveillance video, saw him going in and out to the trash can with a towel covering the bags. And at the time, they might have inferred that he was hiding evidence, but when they testified before the grand jury, they testified that they didn't know what he was doing because it can be inferred through the transcripts that when they went to the garbage can, there was nothing there. That's at the impounded record appendix of the Commonwealth, pages 156.
Didn't they find the trash bag in the wheel well of his car?
So not until eventually, it's not clear in the record that they actually found that, but in the record, on the day after the incident, the police have to ask the defendant, so what were you doing at the garbage can, because we couldn't see, what were you doing? And he says, oh, I had moved bagged evidence into the trash can, realizing you guys might find it. I then decided to move everything to the underneath the spare tire. It's underneath the spare tire of Miss Glasky's car. And the investigators say, so are we going to find everything under that tire? And he replies, yes. And to me, well, based on the case law, that's misleading the police, because they're sending him, he succeeded in sending them down the wrong path in trying to first, try to discover if it's, where's the evidence? It's not in the trash can. They've been misled right there.
I need you to break this down for me. What part is misleading? That he put trash in the trash?
He tried to mislead the police by hiding the evidence in order to divert attention away from him, in order to create the false impression.
Those are big statements and big conclusions. I really need you to get specific, because my understanding from your brief is that he was trying to make it look like she OD'd. So he tried to remove a large amount of drug paraphernalia that would be inconsistent with him having been involved and being consistent with her personal use. Thought he'd only left one syringe, and they ultimately find 3 in the room. What is it that's in the trash that you say misled? What did the police finally recover?
So they ultimately learn that the evidence is not in the trash, and that it's underneath the spare tire at the end of it.
Because he told them that.
Because he told them that.
So I guess I'm missing it. Are you saying that he misled them before he even spoke to them because of his actions?
He misled them.
Is there any case law that suggests that a defendant who does something prior to any involvement with the police whatsoever can then be charged with misleading the police based on his conduct before the police are even involved?
So there's the case law. This is a unique set of facts.
Not that unique. The defendant commits a crime, and then he allegedly, and then he covers it up, and he throws stuff away, and then later on he talks to the police, and by the way, he doesn't tell them about his cover-up. That's not that unusual in a criminal case, and I've never seen anybody charged with misleading the police based on cover-up stuff.
So in the Asciutto case and in Figueroa, it stated that within the meaning of the intimidation of a witness statute, investigations, a defendant can mislead the police in an investigation before that investigation's even started. Here, the defendant, right after Ms. Glasky passed away, did these acts intentionally to send the police off course, and in doing so, interfered with the investigation in a way that the statute was intended to prevent or to deter.
What was in the trash bags? That's, I think, the third time I've asked you.
Yes. So the record doesn't state exactly what was ultimately found in the trash bags.
How do we know it was evidence of a crime?
So already the police find the 3 needles in the hotel, and it can be inferred that the evidence may ultimately have been found underneath the spare tire. But these acts, were all intended to divert attention away from him in a way that did lead the police down the wrong paths, because they had to now investigate what exactly happened in this room, where they had to now ask EMT and they had to ask the hotel staff.
They wouldn't have done that?
They
in a homicide investigation, they wouldn't have done those things?
Had he left the evidence in the room or at least told the truth, the police wouldn't have been sent on a wild goose chase, to use the proverbial term in the case law, to have to find out what exactly happened at this scene and have to go into, they would have at least had the evidence, all of the evidence in front of them, and would have at least, had a more direct path into knowing exactly what might have happened. And so
sometimes I look at the big picture when I'm trying to figure out what we're going to do with cases. The way you're arguing, it seems to me that any time a criminal defendant covers up a crime, anytime, that person could later on be charged with misleading a police officer. Is that your position?
It's my position that when, as the case law states, when they take actions to hide evidence and to stage a scene and to cover up what they may do, what they may have done, with the intent to create a false impression of they were nowhere around, this person overdosed in a self-induced situation where she was alone. When they walked into that room, they could have reasonably come to that conclusion. And then did that lead, per the case law, was it reasonable for the police to have gone down different avenues in their investigation? And here they did. They had to go down certain paths because the defendant required them to take extra steps or certain steps in the wrong directions.
What were the two paths? Either she OD'd on her own, or he was part of the drug situation where she died. So
I don't think that the question is just whether, I don't think the statute requires a view of whether the defendant violated the statute based on one or two directions, because here there's so many different questions to be answered in a potential manslaughter case.
Well, I don't disagree, right? You have a dead pregnant woman. They're going to investigate. And I think that was the point Justice D'Angelo was trying to make. But you're giving us conclusions. You said one thing just now, which is staging the crime scene. And I'm interested in that argument because that's different than not telling the police about the trash or moving the trash. So is your view of staging the crime scene that he moved her body?
I don't think the moving of the body is so much important as the fact that he moved evidence and left one needle next to her body and then texted.
Evidence that we don't know what was in the trash.
He
said it was a spoon and the other stuff she used to shoot.
Yes, yes.
So was it in the trash?
I can't say based on the record that was ultimately found.
So he might have lied about that.
He might have lied about that, but the police did go into the trash, and it can be inferred from the record that they never found anything. So they're on a wild goose chase to find where did this evidence go. He tampered with a scene in which a woman overdosed, and there's so many questions to be found. And then later...
The site's Paquette, and that's a sufficiency case, and I'm going to talk with him about that case. But what is your best probable cause case?
So there's multiple cases. The probable cause case...
Give me your home run case, number one case.
Okay. There's Phillips, the unpublished case Phillips, that requires that, that's where the defendant was found to have possibly misled the police, where he could have truncated the investigation. And that's essentially what the defendant was trying to do here, truncate the investigation.
Published?
That's unpublished. Then there's areas...
I know it was unpublished, but those are things he did after the police were involved.
After the police were involved, yes. And then there's areas which shows that where the police could have investigated a fake party that the defendant made up. They could have gone down that path. They ultimately didn't, but they could have. And then there's the Tejeda case, which ultimately, where the defendant swallowed a bag of heroin, and that was found to not be misleading, but still that's an act that was analyzed underneath the misleading statute.
Well, I want to talk to you for a minute about Tejeda and Paquette and this reasonably could mislead language, which I didn't get right, but it's something like that in Paquette. You keep talking about the fact that what he did mislead the police. Is it your understanding that the law requires that it actually have misled them?
The law is very clear that that the defendant does not actually have to mislead.
Okay, and so going from that, then, how much does it matter what the police know at the time this is happening? So both of my colleagues have said, you know, before the police come, what he does, right? The police know nothing before they arrive.
They know nothing.
By the time they interview the defendant in this case, they actually know a fair amount. Assume for the moment that things happen differently. They get a call, there's a dead woman in the room, they come to the motel. At that moment, they encounter the defendant in his truck about to leave. They know that he's the person who is sharing the room with her. Before they even go to the room, they stop him and they start asking him questions. Has he misled them at that point?
If all he's done is leave?
Yes.
I don't think so, because that's where the Paquette analysis, where what's important is the timing and what they knew, and at that time they may have contradicting evidence, at least in the hotel room, that would contradict what that the defendant was involved in, that they saw him in person leaving.
So now let's say they interview him in the parking lot and he says exactly the same things that he said in the first interview. Is that reasonably misleading at that point? They haven't seen the room yet.
And I'm sorry, what is he saying?
The same things that he says in the first interview that's excerpted in the grand jury minutes. That they came down there for dinner, they went out to dinner, they were intimate, they went to sleep, she took off in the middle of the night, he doesn't know
if they had just walked in, if the police just arrive and that's the first thing they see is, what does the police know at that time? I'm sorry?
They haven't seen the room yet.
They haven't seen the room yet.
So there's a deceased person in the room and that he shared the room with her.
I think he's trying, first the question is, what's he intending? And I think he's trying to create the impression that he's nowhere involved. And then you also need to consider the timing and what the police know at the time. And the police don't know what's in that hotel room. So in effect, it reasonably could lead them down the wrong path at that time. It doesn't really hinge on what they're eventually going to find in the hotel room at that time. It's what is in that moment, what the timing of it, and what the police know at that time.
The grand jury never heard anything from a police officer about, we would have done this if we had known that. Is that accurate?
That's accurate.
Okay.
All right, we have your argument. We'll next hear from Attorney Wunderlich.
All right, thank you.
May it please the court, Brent Wunderlich on behalf of Anthony Wickenbach. I would submit to you that the trial court got this right when they properly allowed the defendant's motion to dismiss on this case, reaching the conclusion that the police were not reasonably misled to where they would materially change the course of their investigation based off of acts that certainly were deceptive on Mr. Wickenbach's part. We're conceding that both the acts that he took as well as the statements that he made to the police were deceiving. Certainly were done in an attempt to minimize his involvement, whether criminally, morally, so forth. But they were done in a way, so I can see that.
At some point, did he say he was afraid he was going to be charged with murder?
There was a reference in the towards the end of the transcript where he did allude that, and he certainly was questioning the officers multiple times, you know, what are you charging me? This is murder, you know, this wasn't murder, so on and so forth. But he did certainly suggest that maybe was on his mind. I would concede that. With respect to his statements, I'll start there, because I think it's...
I can interrupt you because I think the panel has some questions.
Sure.
I interrupted them.
We all interrupted each other. It's a lively bench. I want to ask you the same question that I asked Attorney Sanchez, because one thing that I am troubled by in the law, the way this law is being read, is that it seems to depend a lot on what the actual officers knew at the time. So the law that has been interpreted could reasonably mislead seems to be kind of sliding into, but it didn't actually mislead these officers based on what they knew at the time. So I want to start with, you know, the same hypothetical. They arrive at the parking lot. They know he's been in the room with her. They know she's passed away. He tells them what he told them when they first interviewed him, but they don't know what they're going to find in the room. In your view, is that a violation?
I would suggest that if they had spoken with him very early on in the investigation, within, you know, maybe a short period of time after finding Ms. Glasky's body, we probably wouldn't be here. I would submit, you know, because I think that would be misleading under the statute. That I think the cases are pretty clear. If you look at, you know, some of the Paquette, you know, they try to distinguish between two interviews based off of the time. And so in this case, by the time Mr. Wickenbach is brought into the police barracks and interviewed for those 3 hours, the police have done an extensive amount of work, and it comes in, it's not, you know, they don't, in the grand jury, have police officers, you know, get up there and say, oh, this is what we did at a timeline. So you have to parse through the transcript of the interview with Mr. Wickenbach to be able to understand what they did do, which is a little unusual, but I mean, it's easy enough because they tell them, you know, this isn't just, you know, I don't think there's an argument that the police were just, you know, saying this to try to get him to confess or anything like that. I mean, it was very clear they were very specific as to what, you know, the surveillance video they saw, what was on the video, the individual people that they interviewed. Excuse me, and this is over a 36 to 48 hour window.
And so I think just to sort of try to tie that up, in your view, the lesson of Paquette is, even though the language says whether a statement is misleading for purposes of Section 13B depends on whether it reasonably could lead investigators to pursue a course of investigation materially different from the course they otherwise would have pursued, that kind of has been interpreted as, but did it? Because under the circumstances, what the investigators knew, taking Paquette as an example, right? First interview, they suspect he was in the room when the fight broke out, but they're not really sure. Second interview, they've talked to a ton more witnesses. They know he was there. First time, they could have been misled. Second time, not so much.
Right. I do believe that, I mean, what they know then meets that, what would a reasonable, you know, police officer do, what would be likely to change the investigation. So I do think that certainly when it comes to these statements during the course of the investigation, what they know at the time does matter, because it speaks to the reasonableness of whether or not they would have changed their investigation.
So in a criminal case, usually what we're focusing on, among other things, is the alleged criminal's state of mind, right? Mens rea. Did the person have the necessary criminal intent to commit the crime? Here, I think it sounds to me like that's not really very important, because he could have all the intent in the world, but because the investigators are lucky or good or they're further along in their investigation, if he fails, no crime.
Right. Well, I think I would disagree. I think there has to be an intent, but there's whether it materially or reasonably would affect the investigations is a separate element. So you would have to have the intent to mislead. So I'm suggesting that both are true, essentially, that he would have to have the intent to mislead, and for purposes of, you know, this motion to dismiss, I'm not contesting that. I think there's enough inferences in the grand jury minutes and the test statements made by Mr. Wickenbach to the police that there was some intent to deceive or minimize his involvement. But I would suggest that the Paquette and some of the other cases would suggest that it takes more than just that. It's not just that he was trying to do that. That there is a separate element that it had to have reasonably changed the course of an investigation. What I was submitted to this court, and this goes back to more to some of the acts he did, the police were never misled or could have been misled, because right from the onset, they make an observation that the body was in a position that was...
Hold on a second. I think you've got to parse out the defendant's statements a little bit. He makes a statement at some point where he admits that he goes to the garbage can and throws some stuff away, okay? Let's say the conversation stopped right there. Couldn't that reasonably have misled the police by not going to the trunk of the victim's car? Because he said, I threw everything away in the garbage. So they say, okay, we accept that, we stop, we don't do anything further. It sends them sort of the opposite of not on a wild goose chase, they stop. But wouldn't that could reasonably have misled?
By the time he's made that statement, they've already done all that work.
Okay, but is that relevant under the case law? It could have reasonably misled. Isn't the statement, I threw everything away in the garbage can, couldn't that reasonably mislead them into saying, okay, we're going to go look in the garbage can. If we don't find anything, that's it. Oh, never mind, I put it in the trunk. Well, now they go on to the trunk. I mean, why isn't that fair?
I would suggest that the standard is not just reasonably, but materially change the course of the investigation.
Wouldn't that materially change the course of the investigation?
I think at the time that he's making those statements, I don't think there's anything he could have said at this point that's going to materially change the course of the investigation. They were focused on him from the onset. They grabbed him from a Coast Guard boat. I mean, they had a lot of reasons to, you know, by the time they interview him, he's not leaving. I think that, I mean, and they don't imply that.
See, here's the problem. The way the grand jury minutes are, and I know this is certainly not the defendant's fault, I have no idea when they went to the trunk, if they went to the trunk, what was in the trunk. So again, I focus on, because that's what I'm supposed to, what was told to the grand jury, at least that we have in the record. And one of the things that's told to the grand jury is, I threw everything away in the garbage can. Okay, police say, good to go. Now they may know differently, but they don't tell him that. And then later on he goes, oh yeah, I didn't put it in the garbage can, I put it in the wheelbase of the car. I don't know whether they ever went to the wheelbase of the car before, after, during, I don't know. So what do I do with that?
In the grand jury testimony, I could be mistaken, but I'm fairly certain that there was an inference that the police had done all this searching of the stuff.
Tell me where, because I don't know that. At least unless we only have a portion, I don't know.
I'll admit, I can't recall off the top when they made that. I do understand that's an issue in this case, is by the Commonwealth not introducing the police officers and give a more detailed timeline. It does require some inferences to be made, and I would suggest that there's no evidence that was presented to the grand jury that the police did anything in terms of searching vehicles, cars, trash, post speaking with Mr. Wickenbach. They make multiple statements to Mr. Wickenbach that they know he's lying. Now they had
him sign a consent to search. What was the consent to search?
They had him consent to search. I believe it was he had some belongings on him. I believe that there was a consent to search the belongings, although that's not clear on the record. That's,
okay.
Is it his phone?
They did. I know they asked about the phone, but I don't believe they ever followed through on that. There were some references about they knowing that he made some calls onto her phone, but I don't believe they ever took the step of searching his phone and doing a forensic evaluation of his phone.
You cite Paquette, understandably, but you would also acknowledge that's a sufficiency case. Do we have a probable cause case on this issue?
I don't believe so, no. That is, and that's a part of, I would concede, a a bit of a challenging part of our case. There hasn't been case law developed on the probable cause standard. I would suggest that the evidence in this case is clear that the police, A, were not misled, could not have reasonably been misled by Mr. Wickenbach's actions. Mr. Wickenbach's actions, all they accomplished is putting the focus on him.
So we've pulled apart with both of you each little piece, but you wouldn't disagree that in thinking about this case under the probable cause standard, we're looking at a totality of the circumstances, right? We
Correct.
can't look at it in isolation. I don't see this in the grand jury transcript, so I think I know the answer to my question, but there wasn't a no bill for manslaughter, was there?
No.
Okay.
This case is an older case. It was spent years in them pursuing or doing some work, and then he was never indicted, and they never brought charges against him.
Let me ask you a similar question that I asked the prosecutor, which is, shouldn't there have been evidence presented to the grand jury of what would they have done? I mean, that's the crime here. Again, I love the language that's used in one of the cases, the wild goose chase.
Right.
Shouldn't the grand jury hear that part of the case of what would they have done differently? And was anything like that presented to the grand jury?
There was nothing like that presented to the grand jury. And I would suggest or submit that the reason that there wasn't anything presented to the grand jury because it didn't happen. And if you look through the timeline of events, and I understand the problem is you're trying to parse through multiple things. But if you look at the timing of the interview versus when the time that the police found Ms. Glasky, it's a very short period of time. Through the testimony in the grand jury, you know that the police had to make contact with the Coast Guard and get Mr. Wickenbach off of the Long Island Sound in order to do the police interview, all within 48 hours. I would suggest, while it doesn't directly say we were never pursuing a separate course of action, I think that the actions by the police speak louder than words to that respect. The police find Ms. Glasky in the hotel floor, and she's the way the body's positioned. It's clear that she's been moved post-mortem. The amount of needles they find, it's clear that this was not to them an accidental overdose, and they had to at that point pursue an investigation, which any reasonable officer would do. And I would suggest everything that happened afterwards is in the course of a reasonable officer's investigation in terms of getting the surveillance video, and one thing led to another, and then there was no detour, and there was not going to be a detour based off of what the police found when they found it.
Do you agree with the prosecutor that a cover-up by the defendant, that alone could lead to misleading a police officer?
No, I would suggest that what the Commonwealth is asking this court to do is expand the witness intimidation statute to cover literally anything that a defendant may do to minimize his conduct. If someone were to rob a bank, is throwing the mask so that that may be evidence of a crime. Is that witness intimidation? Is that misleading the police? Is stabbing someone and taking the knife with you? Misleading the police. I think that what the Commonwealth is asking for with respect to the acts that Mr. Wickenbach did prior to any police involvement in this case would dramatically increase the what would be covered under the witness intimidation statute. And I would suggest, while perhaps not explicitly laid out, it's not the direction that the cases have gone. I mean, the cases have been trying to suggest that it would have to materially, change the course of an investigation, which would suggest to me that it's not a situation where anything that a defendant does that's misleading is automatically witness intimidation.
Let me just check with the panel. I don't see any further questions, and your time is up. Counsel, I want to thank you both. This is a difficult case, and you both did a nice job. Thank you.
Thank you.
Are we good on this? Our next case is Educational Divide Reform, Inc. versus Robert Reardon and another, docket 22P0813. Good morning.
Morning.
Mr. Lee, when you're ready.
Yes, I am. Thank you, Your Honor. May I please the court? The trial court decision and the endorsement on the defendant motion to dismiss should be reversed for the following reasons, Your Honor.
Can I just ask you, do you agree with your brother that the standard is Iaquino and not the standard that you set forth in your brief?
Yes, I do, Your Honor. Yes.
So you want to correct your brief?
The standard itself is, yeah, I agree with the standard itself, but I do disagree with the fact on the understanding of the court, the trial courts, Your Honor.
I want to make sure we're all operating on the same standard of review.
Yes.
Okay. And there's a large number of the facts in your facts section that do not have citations to the record. So in the future, you need to make sure you read our rules and comply with our rules, okay?
Yes, Your Honor.
Okay.
The trial court provided 3 bases for its decision. Number 1 is administrative appellate procedure was not exhausted by the plaintiff. Number 2, the EDR, the plaintiff, was aware that the false statement that was provided by the government official, the information that was provided by the government official was false at the time. Number 3, the liabilities regarding the claims against the city in and of itself is precluded under Section 10D.
Do you agree that your client did not file for a tax abatement for those 3 years in which we have the contest?
Yes, Your Honor.
So I guess I'm confused because I know you've tried to recast it and restyle it as something else, but at the end of the day, there was an administrative remedy that they did not comply with. That was their relief. To come here, you would have had to have gone to the appellate tax board. So I don't understand how we can do this workaround that you've suggested.
The reason being is, Your Honor, I guess we are putting our finger at the administrative appellate procedure. But the reason that was impossible at the time is because by the time my client realized it was exempt from property taxation, it was already too late. By then...
Can I ask you about that? If a company or corporation is a nonprofit organization, does that automatically make it tax exempt?
That's my understanding, Your Honor, as far as the property tax is concerned. That is actually where the confusion came from, Your Honor. The reason being is because my client contacted the landlord thinking at the time asserting that nonprofit organization, it should be exempt exempt from income taxation. So what about the property taxation? So contacted the landlord, then landlord contacted the city and the taxing department. At the time, they provided false information and said, it is still subject to property taxation. And also, not only just at the time, Your Honor, they also provided some sort of seemingly persuasive explanation, which is...
Obligation does the government official have to give any information to your client?
But it wasn't what... I don't think they have an obligation, but the...
So he could have said, I'm not telling you, call a lawyer, and that would have been fine.
Right. I believe so, Your Honor.
Okay.
But then they provided...
So what if he made a mistake? Let's say it wasn't deliberate. Let's say he didn't lie on purpose. He just made a mistake.
But if that mistake itself is... Well, I believe that is tantamount to the level of gross, at least, and tantamount to the gross negligence and possibly reckless disregard for the truth, and possibly intentional as well. We are not talking about somebody staffer who just started a career at the taxing department. We're talking about somebody who's been working there for a decade or more and having
the problem is in your complaint, in a timely way, in June of 2018, paragraph 14 of your complaint, EDR's president knew that they were nonprofit organizations and should be tax exempt. Your client knew it.
That's not what it is, Your Honor, though. What we were suggesting...
That's not what it says?
What we are saying is the trial court said we were aware the information was false, but we started, the thought was formed at the time, the outset, the complaint, when they complained and contacted the city. But then when they were given the information, which happened to be false, they were convinced into having to pay tax because the city gave us, my client, information that was confusing, but that's seemingly persuasive. Again, just for the fact because they are not operate in the same line of business as the landlord, meaning the landlord, a Roman Catholic church, my client is an education service provider. So for the fact that they are not doing the same kind of business, so the city department said they are not exempt from taxation.
So the assessor says that. The president of your client says, we're exempt because we're a nonprofit. I don't know, maybe get a third opinion, like you, the CPA lawyer. Your client accepted it to his detriment and waited 3 years to do anything about it.
Well, that's a question for us here, Your Honor. When he had that thought, that was formed at the time before he asked the question.
In June of 2018.
So, I'm sorry.
In June of 2018?
Yes, Your Honor.
Okay.
At the time, he only had that thought, Your Honor. That was just lay person's thought. And that he simply pushed that, but they got a response from the city.
President of a nonprofit.
Well, Mr. Reardon is the director of the tax department.
So he has this thought, he gets other information, and then he waits 3 years until he goes to a cocktail party, and that's when he figures out he's been improperly taxed?
When he received, Your Honor, all due respect, any lay person received a government guidance, the guidance from the government official happened to be head of the department.
Right, he was the assessor, there's no dispute about that.
And if the IRS commissioner said you still have to pay income tax, though you are still a nonprofit organization, I think I would, as a layperson, if I am, I would accept that response, Your Honor.
So what is your best case for being able to proceed now without exhausting your administrative remedies?
We believe this is a misrepresentation.
So what's your best case?
We couldn't find it.
What case am I going to read that says, you know what, he's right?
Unfortunately, we could not find any case law in this matter, Your Honor, but I just can, if I may.
Is there anything by analogy in
Yes,
the
Your Honor.
administrative law realm?
What about this, Your Honor? Hypothetically, let's say I am as a layperson and taxpayer. The government simply come and took the money out of my bank account without my authority, without my consent, without my authorization. They simply took the money from out of my bank account and said, this is a tax amount. I didn't realize that at the time because I didn't know. I don't check my bank statement every single day. Later on down the road, a year after, I just realized, geez, $10,000, let me say $5,000. It was not noticeable at the time, so I didn't realize that. But the year after, well, geez, that was the money there. But then, so I'm going to claim that money because I do not owe the government $5,000, but they took the money out of without my authorization. So I'm going to claim that, but that has been a year since the money has been taken. Then would I be barred from claiming that money because I didn't file it within 3 month time period?
That's not a Chapter 59, Section 59 claim, right? That's a different. I'm looking for something where there's a statutory scheme with prescribed timelines that the SJC has said are absolute, which is what happens with this statute. I'm trying to understand how I can get to your result with your client's failure to exhaust its administrative remedies.
Okay, and unfortunately, as I said, admitted earlier, we couldn't find any case law in this matter, Your Honor. But I do believe, my hypothetical that I just provided, if that was a tagged and labeled property tax that was imposed by the city, but I think we can see some sort of similarity here as well, because we're not just talking about just mere negligence. We're talking a possible intentional tort claim, which is reckless disregard for the truth. And if I've been working for a city for 10 years or more and heading the department, not knowing that kind of basic application of the law, I think that would be tantamount to the at least reckless disregard for the truth, Your Honor.
Counsel, in the judge's decision, the judge says that the plaintiff stipulated that it knew Mr. Reardon's statement was false when he made it. Are you saying that was a clearly erroneous finding?
That's exactly precisely my point, Your Honor. That, when you look at the complaint, the paragraph 14 down to 17, that's not the accurate characterization of the complaint, Your Honor. In fact, what we stated in the complaint, the plaintiff asserted simply asserted simply EDR should be exempt from the real property tax on the grounds the landlord and tenants are a non-profit organization. So that was a thought that was formed by the plaintiff. But when they got a response from the city, they had a seemingly persuasive and reasonable explanation why my client is still subject to taxation. So what happened then? My client bought that argument and explanation from the city, and he was convinced into having to pay tax, and he did, as a law-abiding citizen. And here's the thing, Your Honor, that I got really frustrated. Well, my client was really frustrated. If we go to appellate tax board, they're not going to hear the case because they have no jurisdiction, because the window has been shut down. You only have 3-month time period. You can file the application for the abatement. Obviously, by the time he realized he doesn't have to pay tax, it's been already 3 years. He paid already 2018, 19, 2020. If he go to a superior court, then superior court thinks that this case does not belong there. Where is the justice? Where can he go? He didn't have to pay in the first place. If this honorable court affirmed the decision of the trial court, what kind of message are we sending to the taxpayers?
I think the message is that when a statutory scheme says you have a certain amount of time to appeal your tax assessment, you have a certain amount of time to appeal your tax assessment.
I understand, Your Honor, but that is, as a lawyer, as an accountant, yes, we should have known that, and people would have known that. But as a lay person, when you get a response from the government official, not even a staffer, not even a second grade, we're talking about the head of the taxing department, and getting that kind of information, I think not just once, but twice, he himself contacted them directly. And getting that kind of response, I think we'll buy it. We'll accept that response.
You still have time.
So that is the first argument. In fact, I just covered the, by answering questions, Your Honor, that you have, I basically covered that.
You want to address the Tort Claim Act?
I'm sorry.
Why is there no immunity under the Mass Tort Claim Act here?
If it is a negligent case, obviously the municipals, they are immune from the negligence and all that. But we do believe under Spring versus the geriatric authority of Holyoke, the employees are still remaining liable for intentional torts. But then we were denied the opportunity to prove our claims, Your Honor. That's
For us to say it's an intentional tort, we would have to believe that the assessor knew that your client was tax exempt but told him he wasn't.
yes.
So what evidence do we have in the record that would support that conclusion?
At least when you said Your Honor, when you said knew or should have known, though, Your Honor, we could include that. He knew or should have known the application should apply to his case there. Just for the fact that he's, again, I'm just repeating myself and reiterating it, heading the department for a long time and as serving as a director, he should have known the basic exemption status itself. And that opportunity was denied because we couldn't get the case in, Your Honor.
I think we understand your arguments. Thank you very much, counsel.
Thank you. Thank you, Your Honor.
Sure, I'm going to mispronounce this. Attorney Lepionka?
Lepionka.
I tried.
You did well. Members of the panel, may it please the court, good morning. My name is Franciscus Lepionka on behalf of the City of Cambridge and Robert Reardon. I think the best way to start is to answer a couple of the questions that were asked to my brother. And my turn to mispronounce something. The case released or issued yesterday by a panel of this court, Unquity House, which Justice Hirschfang was a member of the panel. In that case, the court stated the taxpayer carries the burden of demonstrating entitlement to an exemption, and that was not done here. There was a question posed about nonprofits. There are different types of nonprofits. EDR purports to be a charitable organization. The Roman Catholic Archdiocese of Boston, which owns the property where EDR leased space, is a religious organization. when Mr. Reardon was contacted by EDR, he didn't give false information. He actually, the statement he gave, and this is found in the record appendix in the complaint at page 2 and at paragraph 15 on page 10 of the complaint, he told EDRI that the premises were not used for church business, so the real property was not tax exempt. And that's true if you go to chapter 59, section 5, 3rd, clause 11. That statute says that if religious property is not being used primarily for religious purposes, then it's not subject to a tax exemption.
But clause 3 would have allowed potentially for a tax exemption here.
It would if that information was timely brought, which is the burden that EDR had to demonstrate entitlement to an exemption. It was on them to then say, okay, fine, but here, and that goes to the Lady of La Salette versus Board of Assessors in Attleboro, where they addressed that exact issue. But that's not what happened. As this panel has already pointed out, what happened was way past the deadline for timely asking either for an abatement under Chapter 59, Section 59. EDR could have asked for an abatement timely from the Board of Assessors. If he did not get, or if it did not get the relief it wanted, could have then gone to the board, to the Appellate Tax Board, and thereafter sought judicial review. That didn't happen. They had, under Chapter 59, Section 5, an even easier route to go, where they could have gone straight to the Appellate Tax Board. And they could have done that. And the court here had a sparse record, the lower court, the Superior Court. The best they could tell is they could make a determination that the tax bill was received in June of 2018, June of 2019, June of 2020. And the court then said, well, and under the most generous reading to EDR, you have 3 months in which to make a determination has been made that you are not exempt from tax. And under Section 5, you therefore have 90 days at the latest, and this applies as well to Section 59, till September 30th of each of those years in order to either seek an abatement or go directly to the Appellate Tax Board. It didn't happen. It wasn't until October 20th of 2020 that EDR reached out to the city formally and requested an abatement.
Do you think this would be different if the assessor deliberately lied to the taxpayer?
I don't think that would happen.
Hypothetically, let's say it did happen.
Okay. Hypothetically, I believe the Mass Torts Claims Act would still, because Section 10D of Chapter 258 is very clear. And I think it clearly shields the city, and when it comes to collection of taxes, the city and its employees from any liability in the matter of collecting taxes. But again, that's not what happened here. Mr. Reardon did not give any false information. He gave a true statement of tax law, and it was on EDR at that point to follow up, which they eventually did, but too late. There is, I think, nothing can be said better to your point, Justice D'Angelo, than what this court previously stated in the Vining case, which is cited in our brief. In that case, this court explained that the language of General Law Chapter 258, Section 10D is clear and unambiguous. Section 10D's broad language exempts from recovery any claim arising from the named conduct, in this case, assessment or collection of any tax. Any, in this context, indicates all or every. Accordingly, a public employer is not liable for any claim that falls into the delineated conduct. Because the Mass Torts Claim Act is clear and unambiguous that government entities are not subject to tort liability for such claims, this court should affirm the order of the Superior Court dismissing EDR's claims against the city with prejudice. And we would also argue that under Section 10A of the Mass Tort Claims Act, that any claim based upon an act or omission of a public employee when such employee is exercising due care, which he was, Mr. Reardon was in this case, in the execution of any statute or any regulation of a public employer or any municipal order or bylaw, whether or not such statute, regulation, ordinance, or bylaw is valid. Here, Mr. Reardon, as the chief assessor for Cambridge, was exercising due care in the execution of the tax statutes when he allegedly discussed with EDRI its tax exemption status. Furthermore, he was clearly acting within the scope of his duties because that's why he was contacted. He was contacted as the chief assessor about the tax questions. That's the summary of our argument. Their lawsuit is an attempt to challenge 3 assessments with which it disagrees. And having failed to establish the black letter administrative prerequisites to pursue such a challenge, they now attempt to assert theories of liability sounding in tort. This attempt to circumvent the established statutory scheme for challenging assessments should be rejected by this court as it was by the Superior Court. All of their claims, EDR's claims, fail as a matter of law, and the order of the Superior Court dismissing EDR's complaint with prejudice should be affirmed. I'm happy to answer any questions you might have.
I don't see any from the panel. Counsel, thank you very much. The case is deemed submitted. Thank you both.
Thank you.
Our next case is 22P57. And I just want to remind counsel that this case is impounded, so no names, please. Is the other side here? Is the other side here? That's very weird. Okay, we're going to take a break after this one, no matter what then, okay? Thank you. Apologize, Attorney Nearing. You may proceed.
May it please the court, my name is Ilse Nearing, and I represent MC. MC's case is not moot. The extension of an antipsychotic medication treatment order is repetitive and evades review because they must be extended at least annually at shorter intervals. And MC's issue will arise again. There will be another petitioner who is not prepared to go forward at the periodic review with the testimony of a licensed physician or a certified psychiatric nurse clinical specialist. There will, like MC, there will be an IP who has a substantial change in their condition and circumstances, and like MC, will have given ample notice that she does not agree to proceed on documentary evidence.
Can I ask you a question? You say in your brief that the appeal from the one-year order after the evidentiary hearing was noticed. Because these are done with initials and impounded, I tried to find it in our docket. Do you know if it's been docketed?
It has not been docketed, Your Honor.
Okay, so I didn't miss it.
No, you did not.
Right. So, again, hypothetically, if we agreed with you and we vacated the 90-day order, what impact, if any, would that have on the subsequent order? I understand why you're saying it's not moot. I understand they're capable of repetition, but I'm trying to think just in the context of your client as a practical matter. If we vacate this order, what happens to the next order?
I've thought about that, and it seems to me that when there are rulings of this nature about procedural issues, they are not retroactive.
Right.
They go forward from the date of the decision.
So it really wouldn't have an impact on the subsequent treatment order. That would be subject to its own appeal with whatever issues may have been raised.
I believe so.
What if, instead of doing what this judge did, which was to put it over and schedule it for an evidentiary hearing, what if she had made a finding that DMH wasn't ready to go, MC was looking for an evidentiary hearing, as is her right, and that it was an emergency, I'm going to use that word in quotes, such that if she didn't continue the treatment plan, MC could potentially be put at risk, and therefore substituting her judgment that during that emergent period between the date of this hearing and when the evidentiary hearing actually happened. Would that pass muster for you if she had said it was an emergency? I know that didn't happen, but if we want to give guidance to the lower court on this issue, what could she have done other than having an evidentiary hearing that day?
Well, I'm afraid that the MUPC is a harsh mistress. I mean, she defines an emergency at 5-308B.
Right.
And honestly, if the patient was in such critical state of mental health, none of this ever would have happened.
All right, so I'm going to ask you my next hypothetical then. The judge doesn't make an emergency finding. She continues it for an evidentiary hearing, but does not sign the treatment plan. So there's no authorization to administer, and the MC begins to deteriorate. Then what?
General Law, Chapter 123, Section 21 permits the administration of antipsychotic medication in a medical emergency.
Without the need for a court order?
Yes, that's a temporary stay until they can get judicial authorization.
Can I ask a question that's very similar in nature to Justice Blake? What if the judge had granted a temporary extension of 1 day and said, I'm going to give them time to bring the doctor, or a week, or 2 weeks? So my question is, at what point under your argument is it impermissible?
Well, I would argue that even 1 day is impermissible because the justices have said practical considerations, even laudable practical considerations, cannot be addressed at the expense of the constitutional rights of litigants. And here we have, MC has a constitutional right to refuse treatment with antipsychotic medication, and in addition to that, the legislature has promulgated the MUPC with statutory due process entitlements to actually protect that constitutional right. So again, the MUPC is a harsh mistress.
Now,
do you feel, and I don't even know if it's your burden, but did you provide appropriate notice that you were seeking an evidentiary hearing?
Yes, I believe, yes, MC did provide notice. A week before the hearing, she filed a motion in limine and stated she was objecting to the clinician's affidavit. Case law says that affidavit is inadmissible over objection. In addition to that, the MUPC says an antipsychotic medication treatment order can only be ordered or authorized on the testimony of a licensed physician or a clinical, a certified psychiatric nurse clinical specialist. And the only way such an order can be issued on documentary evidence is if the incapacitated person agrees there is no contested issue of fact and the judge makes findings why testimony was not needed.
So I'm going to put on my prior hat as a probate court judge for a minute.
I beg your pardon?
I'm going to put on my prior hat as a probate court judge for a minute. So I want to kind of get granular with you on this because I'm thinking about whether this case is moot or not. There are lessons in this case. And it's not unusual for temporary substitute judgment orders to enter in 90-day intervals for reviews until the one-year order enters. I think that the statute permits that, and I think that for managing sessions, judges go out to that very last 90th date. Giving notice a week before, and I'm not sure that you have the burden, but it's clear that there was notice that under AR you were not going to agree to a documentary hearing. The reality of the session, though, in the probate and family court is there's no way you would have had an evidentiary hearing on a scheduled review date. And I know there's this whole discussion about a trial track. Let's forget about that language. I think that comes out of the Superior Court civil tracking orders. The reality is, in the probate court, you're not going to have an evidentiary hearing on the review date. So to Justice D'Angelo's question, well, I might not have put it out 90 days. Maybe I could have squeezed in a 2-hour evidentiary hearing 10 days out. You say that's not enough.
I say that because the MUPC does not have a waiver clause. It does not say that at the periodic review, if the incapacitated person wants the testimony of these, that they must request an evidentiary hearing or give notice to the petitioner. And if they do not, that will be deemed a waiver of the statutory due process rights.
I don't think she's waiving it. I think she's asserting it, and she's saying, I want an evidentiary hearing. I object to the treatment plan. That would not be my substituted judgment to take Abilify, right? That's what she's saying. But does she get to say, and I want my trial on this day? What do we do about court calendars and court congestion? It's not the same, but I think about those cases with speedy trial in the criminal court, and even court congestion can be a reason why the speedy trial clock doesn't tick. This was 90 days. It was probably too long. I would have tried to do it much sooner, but 10 days? Where's the line?
The MUPC says a year in advance, the treatment order was set to terminate. The MUPC says that the order will...
We already had an expiration date in this case. This was not the first annual review, right?
It was not the first periodic review.
She's entitled to, but your client waived her appearance for this hearing that's at issue. She doesn't have to testify. She may not want to testify for any number of reasons. Do we consider at all the fact that she didn't appear for this hearing as part of the question about whether or not her due process rights were violated? Because I think that's how you framed it, not as an abuse of discretion like the government frames it, but as a due process violation, right?
I had the de novo standard view.
So what do we do about the fact? How do we consider the fact that she chose not to be there? Can you demand under the code an evidentiary hearing and then choose not to be there?
She was represented by her court-appointed counsel, and it was a civil matter, and that was not an issue.
Was the monitor there?
I beg your pardon?
Was the monitor, the Rogers monitor there?
The guardian did not appear. There was a link, but she never used it.
It was a Zoom hearing?
Well, the attorneys were present in the courtroom, but the monitor was not by Zoom. She didn't appear for some unknown reason.
How do you address the mootness issue in the context of a couple of cases out of the SJC, Nolan and FC, that talk about the issue of capable of review? Particularly FC says, person who has been wrongfully committed with an expired or terminated order that may no longer have effect should not necessarily be considered dismissed as moot, and it presents a classic example of issues that are capable of repetition yet evading review, which is what your argument is. But then it goes on to talk about the subsequent hearing, sort of, my words, not the SJC's words, but making up for the fact that there was a subsequent hearing, and therefore what happened at that preliminary stage, there wasn't a legal question. There wasn't any relief that the court could then give.
I regret to inform the court that I'm not really fully versed
That's okay.
with that case because it deals with the Chapter 123.
It is a 123. It is. So in Nolan, do you know Nolan? That was a guardianship out of the probate court, and the SJC said that in that case, it wasn't one that fell into the category of cases capable of repetition yet evading review because her claims are, and this is where I think about your case, heavily dependent on the specific facts Here, those specific facts are 90 days later, the judge entered after an evidentiary hearing a one-year order. Yes, there's been a notice of appeal filed, but that's the specific facts we have here. Trying to figure out how to get over that. You raise a really important issue. I want you to know, I hear you on the issue. I'm not sure that this is the case, though. If an order hadn't entered subsequently and this order had simply expired or terminated by its terms, and we had issues about the collateral consequences of having this kind of a decision out there, that is, I think, a more compelling argument. It's just not the facts that you were dealt. So I don't want you to think I don't hear what you're saying. I'm just trying to figure out, and I don't know what my fellow panelists think, but is this the right case to do it in?
Well, I certainly think it would relieve the congestion of court dockets and get everybody on the same page if there was a ruling that the MUPC does not authorize the extension of an antipsychotic medication treatment order in absence of a hearing, an agreement, or an emergency. Thus, when the date for the annual periodic review and termination has come up, and there is reason to believe that the condition and circumstances of the IP have substantially changed, the right to this hearing and the right to the hearing can't be met before the order terminates and the IP moves to dismiss.
Counsel, you may have stolen my thunder, but I want to ask you about that. Are you suggesting, and I'm trying to use the dates specifically to this case, on October 27th, 2020, the court extended the order. Are you suggesting that a year from that date, and in this case it was October 26, 2021, the court should say, that's an evidentiary hearing unless we hear otherwise, unless we hear the patient agrees or there's extenuating circumstances and a motion should be filed? Your position is that on that year date, it should be scheduled for an evidentiary hearing, and therefore Justice Blake's consideration about the court calendar would be avoided because it should be scheduled that way.
That such a ruling would send a message to all the parties that they have to get themselves in order and make sure that everything that's needed to extend this plan is in place. Because if we say there's a 1-day grace period, a 10-day grace period, then there's going to be, oh, well, it's 15 days. Oh, it's 20. Now it's a month. Now it's 3 months. Then it's 6 months. That a clear message could be sent. I'm sorry, my time.
Well, why isn't the opposite true? There's a presumption, which is I think how the Rogers sessions operate now on block day in most of the probate and family courts. The presumption is there won't be an evidentiary hearing unless the IP requests one.
Well, but that presumption ignores the fact that the treatment order on its face says it will terminate, and the MUPC says antipsychotic medication can only be ordered or authorized under certain circumstances.
In your statement of what you would want us to hold, you used the word hearing. You did not call it an evidentiary hearing. I could make an argument that what happened on October 26, 2021 was a hearing. So you would want us to say an evidentiary hearing.
Where evidence is taken as required by the MUPC.
If requested by the IP.
I think the burden is on all parties to make sure that everything is in place. And as I said before, the MUPC does not have a waiver clause.
It's a great place to end because that's where we're going to start with the Attorney General. Thank you.
Good morning, Your Honors. Adam Hornstein, I'm an Assistant Attorney General. My pronouns are he, him, and I'm here today on behalf of the department. This is a case with potentially profound practical consequences. So let's talk about them, Your Honor.
Well, first of all, I have to tell you, this is not an abuse of discretion case. I know you've briefed it. I know you argue it. You're probably going to want to argue it this morning. Let's just assume I don't agree with you on that.
Let's just jump right on it,
and let's
Your
go
Honor.
to the practical.
Let's do that.
Attorney Nearing is making a very important point, and having sat in the Rogers session, most cases are uncontested.
Yes.
Anecdotally, this is the Amy Blake world. Most cases are uncontested, but there are always, let's call it a handful of cases like MC, who are contesting.
Yes.
So she's entitled to a hearing. Doctor has to come in if she's not going to accept the affidavit. We've said that. That's black letter law. She didn't get her hearing. She got a hearing. She didn't get the hearing that she's supposed to get under the code.
So a few responses, Your Honor. Fully agree with the premises of your question. She got a hearing, and again, we can debate whether or not that is sufficient within the terms of the code, within the terms of, or within the confines of her due process rights. She also did get an evidentiary hearing. It was just 90 days hence. And again, we can debate the propriety of that in light of what the code says, in light of the court's inherent power, and again, the practical considerations that overlay this. But at some point, too, I also want to plant the seed in the court's mind about whether this is the right case to resolve this issue, to provide practical guidance, if we're going to provide it, to the probate court here.
Before we decide whether it's the right case.
Yes.
What is wrong with, I guess, counsel's suggestion and mine, that you have a year date, the treatment order is scheduled to end on that date?
Correct.
As a matter of course, it gets scheduled for an evidentiary hearing on that date, subject to, as Justice Blake just said, the 25 cases where the patient says, I stipulate or I waive or whatever, and there's 2 left. What's wrong with that?
That would be one potential resolution here. I don't think my client would dispute that that is certainly possible, but it would, again, have profound collateral consequences for how these cases are handled. Again, I'm not a policymaker, Your Honor, but certainly I would also hasten to point out that the probate code here, I'm referring to 5308B, which talks about the annual review, also at least contemplates in its last sentence that these orders can be extended under the terms of the code. So
for how long? And I think that's what
capital
counsel,
question, Your Honor. And
I
here,
mean, you know, again, I'll go back to the question I asked her. Is 1 day okay? Maybe. 2 weeks? 3 weeks? 3 months?
Sure.
6 months? At what point do you just go, wait a second, that kind of eliminates the purpose of the statute?
no doubt, Your Honor. 30 days would have been better than 90. 30 days would have been better than 60. 1 would have been better than 30. But looking at, again, let's see where the rubber meets the road. Look at the transcript here, right? We have a situation where neither the court nor my client had any clue that that this case had been marked or should have been marked up for a contested evidentiary hearing. What we have is...
Okay, let's not use the probate language, no offense to my colleague. Marked up.
Yep.
That in my world means nothing.
Okay.
The case is scheduled. She sends a motion in limine that says, I am not agreeing to the affidavit.
Yep.
That's pretty good notice.
So, as I understand it, how the practice works, and again, Justice Blake, please correct me if I misapprehend things.
Very shy, you'll tell.
I know, shrinking violets, all of us. My understanding is that there is, because the vast majority of these cases are in fact undisputed, that it gets just sent to the Rogers review session. And you'll see in the transcript the court saying, this isn't marked up for an evidentiary hearing. If you want an evidentiary hearing, you need to go see this other judge. And you know, when's the nearest opening? 90 days? You know, it's October, you know, it's the holidays coming up. We can get you on Judge B's calendar in January. So let's do that for the evidentiary hearing. Again, I'm not saying that 60 days wouldn't have been better or that 1 day wouldn't have been better, but again, reflecting the realities of how the probate court in Worcester operates, even the judge who was hearing it wasn't the right judge to have heard it that day for an evidentiary hearing. And
nowhere in any statute that I'm aware of that says it needs to go to the X session.
Again,
that's a probate court problem.
It is a probate court problem.
Let them fix it. Now let's weave it way back to where you said. Why isn't this the right case for us to go, I don't care about the probate court standing orders. I don't care about scheduling. It says 1 year, unless there's those exceptions, means 1 year. Why isn't this the right case?
Why isn't this the right case? I think Justice Blake was asking the right question, which is, what do cases like FC and Nolan say? They say that this exception to the general mootness rule applies if, and only if, you know, or the reason that it exists is because we want respondents to be able to have the ability to challenge the merits of the underlying decision. And here, where the respondent had 3 times before challenged the merits, has subsequently challenged the merits at the probate court, at the evidentiary hearing that was demanded, and could have taken an appeal from that January of 2022 order. And again, the appeal was noticed. It has not been docketed. You know,
So we have to wait for somebody who maybe is not openly psychotic to have this order placed in 90 days, 60 days, and that's when it's going to be right. Because I'm trying to figure out, when I read counsel's brief and your brief, when is something like this not going to be moot? Because it's always going to be moot.
Sure. Let's take this as a hypothetical then, Your Honor. After the 3-month review, right, or excuse me, at the outset, let's assume a totally different respondent. First time out of the gate, says, you know, there's a substituted judgment order in place. You know, no appeal is taken from that. But then a year later, you get the 3-month window. You get a 3-month. Oh, no one's here to hear that today. You get another 30 or 3-month extension. Take that up on appeal. Again, there hasn't been any adjudication on the merits, as there has been here, both previous and after. You know, the point is, I think that the
No, hold on. Let's
slow
down for a second.
Let's do that.
30 days comes.
Yep.
There's no way in the world, in our world, that case is getting heard by the appeals court within 30 days, 60 days, 90 days. So that patient is either going to be discharged or forcibly medicated. If she's forcibly medicated, you maybe not you, because you seem very reasonable.
Yeah,
maybe a colleague who's not so reasonable is going to come in and say, it's moot. She had her second hearing. The judge said medication, so this case is irrelevant. Or the patient gets discharged. Your colleague's going to say, oh, it's moot. She got out. See, everything worked great. I'm failing to see how your hypothetical says it's not moot.
Well, again, let's cycle back to, again, the rationale of cases like MC, like FC, like Nolan. The reason that this exception applies is not just for narrow concepts of repetition and evading review. It's to afford respondents the opportunity to challenge these decisions on the merit, to remove any potential stigma associated with orders like this one. And whereas here, the respondent has had opportunity both before this continuation and after, and again, potentially there is still an appellate right that exists. I don't want to express any view on that. I know this court doesn't want to express any view on that, given the lapse of time. You know, that ability to challenge the underlying order on the merits, to remove any potential stigma that attends these orders, is the reason why this exception exists. Why it's not just for the sake of giving guidance, even if it would be important, even if it might be practical to the courts. And I will fully recognize my client has told me as much, that in a case like this, guidance may well be helpful to the probate courts. But
in that respect, though, what's DMH going to do if we adopt what I'm now going to call the Judge D'Angelo rule, that every 1-year review is an evidentiary hearing unless you hear otherwise? So DMH is bringing every clinician in every time. Is that
my
what
client
you'd have
has
to
told
do?
me that that will be challenging, but that if that's what the court orders, we'll make do.
Perhaps the probate court could make a standing order then that says if there's going to be a hearing, maybe it's the patient has to say, I want an evidentiary. I mean, there could be other things in place before then, so DMH is not overrun, and neither is the probate court.
Yeah, again, my concern is not just for my client, my concern is for the probate court. Again, I think all of the questions here have been immensely practically driven, you know, and I sense that and I appreciate that. But, you know, we obviously take our cues from the court, DMH does, as does the probate court here, so.
If MC had filed with the single justice, you would have argued it was interlocutory and she's not entitled to an appeal, right?
Probably.
Would you be right?
Probably.
Thus, the question of capable
No,
dating.
I hear you. I hear you, Your Honor. Again, my understanding of, again, cases, again, the cases that you cite, like Nolan, like FC, put this case on the line of being moot, not.
Well, and I think that's the issue, right? The specific facts and circumstances.
Yes.
This wasn't a brand-new guardianship in Rogers' case, and maybe that's what's different. Maybe the right case to make some change is where we haven't had a history.
Yes, I think that is the right answer, because again, this case presents really interesting issues and has some really practical effects on how my client, how the probate court, and how respondents, like our respondent here, interface with the court. So no one disputes any of that, but this might not be the right case.
Haven't we potentially gotten some guidance from the SJC in the context of Section 7 and 8, where they've been very strict regarding time limits and basically saying, if it says 3 days, it means 3 days. And even where a district court judge said, I'm going to start the hearing, says, what's your name? My name is Dr. So-and-so. Okay, we're going to continue it. The SJC has said, no, that's not a hearing. So doesn't that kind of give us some guidance as to what the SJC would say if we said, well, we're going to put it on for a year date, but if it's in session A, we'll continue it 90 days, but if it's in session B, it's a real evidentiary hearing. Haven't we gotten some guidance?
Let me give the court its least favorite answer. That is a slightly disanalogous situation. But yeah, look, if we're in the business of reading tea leaves, is that an analogy that we can draw? Sure, it doesn't seem.
But a commitment is different than medication.
Yes, and this is why I say it's a disanalogous situation.
MC was not institutionalized.
No, this was just administration of medication and an appointment of a guardian. That is all. So it is, again, dissimilar, but it's a really interesting and novel hypothetical, and I think it is this entire case is thought-provoking, and that is
the statutory/constitutional right to liberty.
Correct.
Which means freedom in one context.
Yeah.
And the constitutional statutory right to freedom meaning no forcible medication.
Correct.
And that's
and here, at the end of the day, I think what we have is a probate court judge trying to balance these really hard interests, right? Respondent wanted an evidentiary hearing to demand those constitutional rights be vindicated. Great. How are we going to do that? In 90 days, we'll do that. But in the meantime, you've been medicated for a long time under this court's orders that have been reviewed by the appeals court, and the court's obviously allowed to rely on those prior facts and prior determinations to disrupt that medication, the orders of treatment. You know.
Well, she could have not signed the treatment order, and if
Yes.
MC deteriorated.
Proceeded under again, Justice Blake, questions that you asked opposing counsel, I think were good ones. Could we have done this as an emergency order within the meaning of 5308B? Maybe. Could we have done it, waited until she deteriorated under Chapter 123? I mean, it strikes me as being suboptimal, but yes, that's an option as well. Again, there are no easy choices. There are no easy answers. And perhaps, I don't know, that counsel's really looking hard at cases, again, like the Nolans and the FCs of the world, to see, is this the right case that we want to provide guidance on, or does that mean the opposite? This is the case that we want to provide guidance on. I will, seeing as my time is about to expire, submit that thorny and extraordinarily hard question to this court's kind consideration, unless your honors have any additional questions.
I think we understand it. Beyond that, I don't know.
Understanding is all I could hope for.
This is a very challenging area of the law, and you both
Yes.
did an excellent job, and the arguments were very helpful, so thank you both. We are going to take a brief morning recess, and we'll be back in between 10 and 15 minutes.
Court, all rise, please. Please. Court is open. Please be seated.
All right, our next case is Nataline versus Nataline, docket 22P327. Before we start argument, I wanted to just note for the record that the court received what I would consider to be an ex parte communication from one of the parties who is represented by counsel, attaching things that are not part of the record. I'm going to enter an order at the clerk's office to strike that. That was wholly inappropriate. I will tell you that the justices did not review it, and I don't fault counsel. I represented clients, I understand that, but for the record, I want to be clear about that. So with that,
thank you.
Happy to hear your argument.
I appreciate that. I actually called the clerk's office a day or two ago when I found out, so thank you. Good morning, Your Honor. Gordon Schultz for the appellant. I'm here today to ask that the court vacate the order which dismissed my client's petition and give her an opportunity to reestablish the relationship that we had with her two granddaughters before her son's death. At the least, I'm asking that you would provide her with a vehicle to do so in order that the court return this to the court with an order that a guardian be appointed to investigate, vet the circumstances, make a report, all of the usual things that we generally do in the probate court to determine whether...
Can I ask you a question about that? I saw the cases that you cite in support of the proposition that the court had the authority to support, to appoint a guardian ad litem. Do you have cases where that actually happened? Where a guardian was appointed in these circumstances?
Sure, yes. I think I recited in the brief 3 New Jersey cases. I would like to say that, I've always thought Massachusetts, and I think is an enlightened a court, and over the years I've practiced, I've seen changes made. When I first got into this case, it was new to me. When I got up to speed, I saw a number of other states, including New Jersey and even Tennessee, that I thought, in my own personal view, perhaps were more enlightened in terms of where we stand here in Massachusetts now. The 3 cases that I cited in New Jersey, all with respect to the impact of the death of a parent. And by the way, I think you'll understand this. This is a case of first impression for us, because I have found no case that addresses the issue of harm in the context of the death of a parent. Many, many other jurisdictions have done that, including New Jersey. I researched...
I just want to make sure that seemed like a very elegant way of saying that there's not Massachusetts precedent for this.
We're in with respect to that issue, we are, I won't say uncharted waters, because I would like to think that other jurisdictions have charted it, but we have not reached it. I think, by the way, just because I see this as such an important issue for the court, and happy that perhaps my client, not happy that she has suffered through what she has suffered through to get us to this point, but that this case may serve, if the court is inclined, to move the ball forward in an area that I think is tremendously important.
In order to do
this, given the children and all of that.
In order to maybe do that, can you distinguish this from Frazier v. Frazier? How do we get around that?
I'm sorry, I could...
How do we get around Frazier v. Frazier, the case that's cited by opposing counsel?
I think there is enough here to get us over that rail. That's the posture that I have taken. All of the detailed facts that we have submitted to the court, I think, are enough. What is enough is going to be up to the 3 of you, because it's a de novo review. I think the facts are well beyond the 2 cases where visitation was declined. That was just a direct approach to asking for visitation, not the guardian. I see I guess what I'm trying to say to the court is, in a case like this, even if I say to you that I'm right on the cusp of those facts, I say to you that there's enough there, given what's at stake, the children, the relationship with the grandparent, the children, and what's in the best interest of the children, to at least give us the shot, give us the guardian, let the guardian go in and document the facts. These cases come up on affidavits, undocumented in certain cases.
But let me ask you, so aren't we opening up a floodgate? So in every case where a grandparent says, I had a relationship, and on affidavit it will be harmful if the children don't have a relationship with me, we're going to have a GAL in every case?
No, I'm going beyond that. I agree with that, and that's been the traditional opposition to doing that. I think what I'm asking the court to do is to properly conflate, in this case, the fact that we have a death of a parent. And to me, that changes everything. Because if you look at the other jurisdictions, they go that extra mile. Here, I made the point in the brief, I found it fascinating and very forthcoming in my mind, that Tennessee, in its statutes, and there are others, I just happen to pick that one because I had brief limitations on page, Tennessee creates a rebuttable presumption of harm to the child on the death of a parent. That really moves the ball forward.
It does, but we're not in Tennessee. And
I agree.
The statute here creates a rebuttable presumption of fitness for the mother, and what flows from that is a presumption that the mother's decisions about child rearing are reasonable and in the best interest of the child. So dealing with the statute we have here, your client's first task is to rebut the presumption of fitness on behalf of the children's mother. Can you describe for us what in the record does that for us?
Well, there are three issues that I pointed out with respect to the harm. I believe the issue of the dental work that was needed. I'm trying to remember. I know there were three. I read the brief this morning. But there were three that were cited. One was
there's the dental issue,
therapy,
and then there are the two incidents, one with each child that the grandmother thought were sufficiently egregious to report them to DCF, right?
Yes. And then there was the fact that they're in therapy, that the kids are in therapy, and we don't.
The kid's father has died.
Well, that's my point.
So
that's precisely the point that I'm encouraging this court to take a look at, and how New Jersey, as just one jurisdiction, has rationalized that by saying that when you have that, their research and analysis supporting their decisions found that the absence of grandparent visitation have a tremendous impact on that. And we don't know. What we do know is those kids are in therapy. What we may presume fairly, New Jersey, if we were, and I agree, we're not New Jersey, but if we were, that, that's the kind of thing that we need a guardian, because there's been an absence of grandparent visitation now for, the pandemic, which changed the world, but let's call it 2 to 3 years, which is most unfortunate. Nothing you can do about it, but
my understanding of the timing from the record, and please correct me if I'm wrong about this, is that the grandparent visitation ended roughly contemporaneously with the filing of the DCF report by the grandmother. Do I have that right? I
believe that is correct. One might suppose that it was retaliation, and that's what my client assumes. That's what I would assume. I think what's interesting to me is that prior to the death of the father, this was a normal relationship. This was the way it should be. I won't recount all of the facts that are in the brief, but they all lived together for 7 months in Florida. The grandmother made extraordinary efforts while her son was dying to take care of this family and supply support, money, caring, emotional support, and all of that. Moved with them to Florida. I mean, my God, you know, how much more can you do? And then, from what I can see in this record, at least what's there now, was abruptly cut off, and whether it was probably a retaliation, that itself may suggest something. Why would you do that? I don't know, but it's troubling. It's obviously troubling, but I think that here I would like to see and encourage this court to consider the fact is we have no precedent. We have one close precedent. I put it in the brief. There's a case involving the father who's incarcerated. So there's however, I think we can all.
Do you think that that your client has to get over the rail, though, under Blixt and Troxel before you can consider a GAL appointment?
That's a great question, and I've thought about that a lot. And to be honest, that's a balancing act. I don't honestly know how to answer that. I think that you could argue that.
Because New Jersey, it's a presumption created by statute because of a death, right?
I guess what I'm trying to say, or am saying to this court, is that changes everything. I would like to encourage the court to consider that because, especially as we have no precedent, and just quickly to go back, you know, there's an obvious difference between incarceration and death. I mean, I didn't go beyond the facts of that incarceration. That individual may have gotten out at some point. I don't know if it was a life sentence. Even if it were, family visits incarcerated people, there is still a relationship. Death is permanent. There is none.
Timeline-wise, I want to make sure I understand the dates. The last time the children saw Grandma was August 31st, 2018?
I believe that is, if that's the, I believe that's correct.
And then Dad died in October of 18. And then she filed her petition in 19, and for reasons that I don't know, it's now 2023. So they haven't seen Grandma in, this summer would be 5 years?
Whatever, if that's doing the math, yeah. I mean, and I get that. You know, justice delayed is justice denied, but it's, and we had the pandemic in between, and I don't, although I think, you know, the kids are now 13 and, I believe, 13 and 9, so they're of an age that, you know, they're not infants. There were some delays here based on the emotional circumstances. It took my client a long time to come to, I mean, think about it. I don't know whether, some of you perhaps, I'm a grandparent, I have 4 grandchildren. If I couldn't see my grandkids, I don't know what I'd do. And so
these are some of the most heartbreaking cases.
They're absolutely. Well, and coupled, I keep coming back to that's bad. Well, that's bad enough. Now, juxtapose on top of that the death of your son.
But what I struggle with, just under the rubric of the law, and that's what I can't use my heart, I can only use my head, right? So we have a parent's constitutional right to parent. There is no equal right to grandparent.
I guess the best, if we follow that strictly, I guess my response to that is, I think the record shows enough to get there, and then if you add the death of the parent on top of it, then at least I think the mid-ground, the fair ground, which doesn't involve or perhaps minimizes the cost, is to have the guardian do the work. We don't have to pay legal fees.
I guess I'm missing that you're there. That's the piece that I think I'm having a struggle with. I get that Grandma took care of these kids. I get that she saw her. I think in the record it's 3 to 5 times a week. But the missing piece, or the piece that the judge found was missing, was that there would be significant harm. For example, there was nothing in the affidavit that said that the children, and I know you want us to infer, that the kids are seeing psychological help from not seeing grandma. There's nothing in the record, and I know it's difficult to show, that the kids are crying hysterically at school and complaining that they don't get to see grandma. There was none of that.
Well, but that's my point. You can't get, this is what New Jersey...
No, you can,
this
just,
is what New
just by the things I just said. Why can't you get there?
You're right, but that's what New Jersey cases said. To answer Judge Hirschfang's question, they appointed the guardian to get that information. That's just what they did, recognizing
but that's not what the law is here. Here is you have to make a you have to show significant harm before you even get to that.
I understand.
So you want us to change it?
I want you folks to move the ball forward in a place where I think it should go. And I think it's fair to go there. It's so logical. It's so what you say, you're right. And that's what, when the justices, when they considered that question in New Jersey, they had to sit there and said, yeah, how are we going to figure that out?
Did you ask for direct appellate review in this case by the SJC?
I'm sorry, Your Honor.
Did you ask for direct appellate review in this case with the SJC?
I wasn't counsel. You mean at the...
In other words, did you seek to have the appeal heard in the first instance by the SJC as a case of first impression?
No, I didn't. Okay. No, I didn't think that. But I like Justice D'Angelo's approach because they had to wrestle with that same issue. They had to wrestle with it. And yet they concluded in not just one, in a series of cases that developed. They say right in those cases, we need the guardian to get the answer. Now, when you get the answer to that question...
All right, now your time is up. I let you go on a little bit, but I'm going to have to leave it there and hear from Brother Counsel. Thank you very much for your argument.
Thank you very much.
Thank
you. Mr. Newton?
Yes, Your Honor.
Do we have your appearance?
Yes, Your Honor, my appearance...
It was listed as pro se for some reason.
My appearance was filed on the docket several times.
Okay.
Months ago. I actually filed the brief that you read.
That's what I thought. All right, you're here, you're in.
So I saw that this morning. I brought it up to the court officer. I was
Wonderful.
like, I don't know what's going on here, but my name's all over the record and I've been getting the emails.
All right, Mr. Newton, welcome.
I'm glad this is a lively bench. I came early just so I could watch. As I spent all day in your favorite neck of the woods, Essex probate court all day yesterday, and it was not as lively. So
you may regret those words, but anyway, go ahead.
It's
I'm going to start. You know where we're going.
I know where you're going.
I appreciate everything opposing counsel just said, which is, how do you prove this stuff without a GAL?
This is the problem. Counsel is going to New Jersey and saying, look at New Jersey. New Jersey has a different statute. Those cases interpret a New Jersey statute.
I'm not talking about New Jersey. I'm asking you the question. Here in Massachusetts, I know what the law is, but you have grandma is cut out of the picture for whatever reason. Let's say it's not nefarious. Grandma's cut out, and now grandma is left with, well, how am I going to prove if I don't get to see the kids, I don't get to visit them, I don't have any contact with school, I don't have any contact with their doctors? How does a grandparent get over the rail of showing significant harm to the children unless I can see her? How do you get there?
The cases that show significant harm have been cases in which they basically said, we can tell there's significant harm overriding mom's presumptive rights because of physical abuse issues. I actually believe...
That's all from stuff beforehand.
Yes.
I read every one of the cases, and every one of the cases talks about stuff that happened beforehand. Mom's a drug addict. There's physical abuse, things like that. This is different. This is, mom just doesn't like grandma. And I don't know what's going on. Mom doesn't like grandma. Let's assume that is the case. And now, how do we find out that the kids are hysterically crying every night because they don't see grandma? They are going to the psychiatrist because they don't get to see grandma. They used to see her every day. How do we find any of that out in Massachusetts?
For instance, Your Honor, unfortunately, it's her burden. It's a pleading burden. The statute gives mom a presumption. So the truth of the matter is, that's her problem, quite frankly.
But it's
now,
not.
If I
it's
was
the kid's problem. And that's the best interest of the children always goes above everything. I don't care about mom. I don't care about her. I care about the kids.
And so do I. And in this particular case, if we want to dig into it, visitation stopped before father died.
About 2 months
About
before,
2 months
right?
prior. Father wrote a codicil to his will.
But we don't consider that under the Blix-Troxel analysis.
I understand, but if we're going strictly under the Blix-Troxel analysis, then all we are talking about, this court as recently as 2022 in Bastieri, and I hope I didn't massacre that name, I probably did, has reaffirmed these standards. We have 20 years of case law starting back to Blix, and as recently as 2022. This case is no different than Frazier. Matter of fact, I think the facts were better in Frazier, quite frankly, and they still couldn't get over that burden. The way it is played out is the presumption that puts it in their court. She must establish.
Can I ask you a technical question?
Yes, Your Honor.
I think Grandma filed initially pro se, and then on August 14th, 2020, probate court paper 23, there was an amended affidavit. Did she seek leave of court to amend? Did you assent to that?
She had 2 attorneys, actually. She filed in 2019. I can't remember the first attorney. I believe it was out of Turco Legal. They filed the initial. I filed a motion to dismiss. She fired them. She hired Porcello Law. I cannot.
So with counsel, there's at paper 23, there's amended affidavit. She would have needed under Rule 15 either your permission or the judge to allow it. Did she seek that permission? So is that affidavit even proper?
Off the top of my head, Your Honor, it was so long ago, I can't remember if we litigated that issue or not. I remember my position was even under the amended.
I don't see a motion to strike on the docket, or a motion to allow.
I can't remember.
Okay.
To be honest with you. It was so long ago. I know my position was even under the amended that there was no way that she still was meeting.
So even if we consider that, you say she doesn't?
Yes, Your Honor. Even if you consider if she doesn't, because this is the way the case law reads when you look at Blix, Frazier, Bastieri. Essentially, the court has taken 2 different approaches to it. They've said, listen, they call it pre-existing significant relationship, but the truth of the matter is it's a de facto parenting standard. It really is. When you read it, they're basically like you took over as a parent. And if you go down that case law, that is a difficult bar to cross even in situations where somebody acted as a parent in some things to get over that. But essentially it's de facto parenting. And then you can't just say, well, there's going to be harm from not seeing grandma, or not going to be harm from not seeing. You have to establish some type of harm. Are there police reports of these children in trouble? Subpoena the schools. You opened up the case, subpoena the schools. Hire an investigator, follow them around, which, quite frankly, she did.
Can she do that once she files and serves the complaint?
I think she could send out potentially a subpoena, and then we'd litigate it. But as this court has, again, pointed out as recently as 2022 in Bastieri, the pure litigation can be disruptive to the children. Now, I understand we're not out trying that case. We're talking about a motion to dismiss. And my position, quite frankly, if we were at the trial court, is that pure litigation in these facts and circumstances, as I understand them, I was the lower counsel, would be disruptive. But the court has basically said, listen, we can't trot all over mom or dad's rights. Mom has presumed validity. We have a statute here that says it. The U.S. Supreme Court has essentially said it as well. We have a constitutional right here. Now,
so let me ask you the same question that I asked Mr. Schultz, which is, would grandma have to get over the Blix-Troxel bar before she can seek the appointment of a GAL? Because you just told me she could do some discovery.
She could try. Now, whether or not down in the lower court, I very well probably would have filed a motion to quash and quite rarely said, listen, I got a motion to dismiss pending, let's have it done. How that would play out, I do not know. But she does, because this court, as I said, the pure investigation, the pure case can be disruptive to the children. So we have to have that bar. Our statute basically says we have to have that bar. You have to reach the bar before we're going to let you invade the most basic of parental rights.
And do you say we're reviewing de novo or for an abuse of discretion?
Quite frankly, Your Honor, de novo or abuse of discretion, it doesn't meet the burden. But I would...
Well, we don't get to pick from column A and column B.
I understand, Your Honor. I would say, realistically, it probably, I would say it's probably de novo if it's just on the pleadings. But even de novo, you got to get over that Blix bar. And even if you get over that Blix bar, to establish a pre-existing, significant pre-existing condition, which is de facto, then you still have to establish actual harm, not some, the children might be sad. Of course they're in therapy. Now, one thing I do want to point out, counsel has basically, and I understand, counsel has basically said, this is a death. But apparently that decision was made, and it's easy to infer, she hadn't seen the children 2 months before he died. She's trying to override her own son's decision. So when she comes in and says, when counsel comes in and says, this is a case where he has died, it's not that visitation stopped prior to his death.
Well, but I mean, there's obviously a rift in the family, right? I mean, if you look at the affidavit, you know, the grandmother was not notified of her son's death. She was not invited to participate in the memorial services. That's obviously, that's beyond the scope of what we're looking at here, but under those circumstances, it doesn't seem fair to me to put so much weight on the behavior during those 2 months. And the question is not, did the parents cut grandma out for some reason? The question is, was the relationship that the children had with grandma sufficient that they would suffer this kind of harm without the relationship? And given the weight of the multiple years of the relationship balanced against 2 months of family disharmony, I'm not sure that one should give those 2 months as much weight as you are trying to give them.
I would say that the court can't give weight of the death of the parent either, because that is not what the case law is. Just
I agree, but let's look, how about we look at the fact that for however long, and it was a substantial amount of time, grandma took care of these kids 3 to 4 times a week. She is the one that was responsible for at least some of the medical care of these children. That's something compelling to me. Aside from Dad's death and aside from Dad's wishes, frankly, she was, I won't use the words you use, I don't know if it rose to the level of the de facto caretaker, but she certainly played a substantial role in these children's lives.
And to be fair, most aunts do, most uncles do, most grandparents do, most older siblings do, but it plays significant roles. We use villages. We do. We use villages to raise children. And we look at what's in the best interests of the children. And we presume that the parent has a constitutional right, and we presume that they are fit. And there is nothing to show that she is not fit. And quite frankly, it's not her standard. If we do this, we open up the floodgates. The legislature has created a statute.
You know, I hear that. I don't care about the floodgates opening. Like I said at the beginning, I care about what's in the best interest of the children. And I'm struggling with, I know what this, I mean, I questioned opposing counsel about it. The burden is certainly on grandparent. I just don't know how grandparent meets that burden. I don't think I want a private investigator, frankly, following around at the time, it would have been a 9-year-old and a 5-year-old. That goes a little too far. Your suggestion of subpoenaing the doctors raises many more issues than perhaps the court saying, grandma took care of these kids, had a substantial role. What's the harm in appointing a GAL to talk to these collaterals to find out what the kid's best interest is?
To be fair, Your Honor, this case, as you noted yourself by asking brother counsel, how is this any different than Frazier? It's not.
Maybe we want to move the ball, like counsel's saying.
Then you would be basically taking your judgment, and I, with all due respect, and telling the legislature their job, because they created the statute. There's a reason that he had to go to New Jersey. The reason that New Jersey says, yeah, let's get those GALs is because there's a statute there that says, in this situation, we presume it. This is our presumption. So of course we have to have a guardian ad litem. With all due respect, we are in the wrong hall of government today.
I think we're right where we're supposed to be.
Yes, Your Honor, but I mean, really the problem is, if they want this change, it's really the legislature. And the court took the legislature's law and interpreted it for 20 years. If the ball was going to be moved, it should have been. This is not like a brand new issue. The court has decided consistently this issue the same way for 2 decades. Quite frankly, and I believe each time it has been more and more narrow. When you go back to Blix and you work your way up through Frazier, and then you ultimately end up with the last one from last year, which I'm sure I'm absolutely massacring Balstieri. I've never been good with names. I'm surprised I get by, quite frankly.
Lucky you're Newton and not Hirschfang.
Well, that's been the advantage. Quite frankly, anything more complicated than Newton, I think I would have been in trouble. But this is something that's been litigated time and time again. These facts are no different. 2019, these facts came before the court. 2022, the court has issued another ruling. If they don't like the law, they need to go, the statute, they need to go change the statute. Quite frankly, it's been interpreted for 20 years. I see I am almost out of time. If there's no further questions, I will conclude my argument and rest on the papers.
Thank you both very much. It's a very difficult issue. There's obviously a lot of emotions involved, and we appreciate that, but we've got to do our job. And with the law, I don't know where the case will come out, but you've given us a lot to think about. So thank you both.
Thank you.
Our final case this morning, we're still in the morning, is Dion versus Flynn, docket number 22P929. Mr. Rourke, when you're ready.
Thank you. Good morning.
Good morning.
May it please the court, Craig Rourke on behalf of Kathleen Dion. And thank you for hearing our case today on an expedited basis. We appreciate you. We're here today asking that this court overturn the Superior Court's judgment of dismissal. The Superior Court has jurisdiction over this matter. Ms. Dion has standing to bring it, and she has plausibly articulated claims beyond the speculative level upon which relief can be granted.
This is a very interesting, creative case, in my view. One of the things that I know that you say in your papers multiple times that you're not challenging the nature or validity of the marriage. But one of the prayers for relief in the complaint is to invalidate the marriage. So can you help me with that?
Certainly. And, I mean, I guess that's focusing on the relief requested rather than the harm that we're alleging. And that's what we're doing here. It sounds in tort because the plaintiff's claims derive from the harm caused by the defendant. We don't need to invalidate the marriage in as much as we're looking for a monetary judgment. We're looking for monetary damages.
So the mother committed fraud, tortious interference, and unduly influenced dad, which then resulted in daughter getting less of an inheritance. Is that my shorthand version? Is that what the argument is?
Yes, that's exactly right.
Okay, can we talk about undue influence for a moment?
Okay.
He didn't sign something that mom undue influenced him to sign, like we see in so many probate litigation, a revised will, a codicil. So she claimed under her statutory share. Where is the undue influence? The only place I see it is in the marriage.
Right, so they were divorced. I don't know if that was clear.
It's very clear.
She divorced him, and then...
In 2017.
Yeah, 2016, I think it started.
Then
but
she moved back in 2018.
Yes.
And then they got remarried in 2020, and unfortunately, he died days later.
Yes.
What did she undue influence him to do?
To participate in the marriage ceremony.
Thus, my initial question.
Yes. So it arises because that's part of the scheme of fraud. What they did was...
You're challenging the marriage.
No, not at all. I'm saying that that was the method that she used in order to effectuate the ultimate fraud.
One of your elements that you're going to have to prove is that the marriage was fraudulent. Would you agree with that?
I would agree that I would agree that obtaining the marriage certificate was fraudulent, is what I would say. And we've
all right, okay, parse that out for me different than what I just said. The element of, I think, one of the elements of undue influence in this case is that you would have to show the marriage, that was entered into fraudulently, right?
Yes, and that doesn't need to be invalidated to prove that or to recover monetary damages for it. And we did that by getting some deposition testimony from the physician's assistant that signed the letter that the defendant presented to the Malden city clerk in order to obtain the marriage license, which was then used to get the marriage certificate that was presented before the probate court to elect for the surviving spouse share and to reject the existing will.
Are you saying they were not lawfully married?
What I'm saying is that the defendant obtained a marriage certificate through unlawful means.
Yes, and does that mean that they were not lawfully married?
I think that that's challenging the lawfulness of the marriage. What I'm saying is that she obtained it without his signature on the application for the license. The physician's assistant did not know that she was issuing the letter for that purpose or reason, and that he wasn't capable of entering into a marriage at that time. Now, that she managed to do that is one thing, but what she used it for was to take my client's share of the house. And that can be monetized through monetary damages. We don't need to...
If she's married, right? If she is married, if two people are married, and one of them dies...
Yes.
The other one is entitled to a spousal share. Do I have that part right?
Yes.
Okay. So if they were lawfully married, then she was entitled to a spousal share.
I'm not sure what I guess lawfully, do you mean was there a certificate proving, or... I guess this is where I get confused.
Well, I mean, I think it's where we're getting confused.
I understand that this is
a... There's this concept that you seem to be putting forward that that a marriage could be valid, but that the marriage certificate was somehow fraudulent. And I don't know a whole lot about being married, other than that I think I am, but now I'm starting to wonder. But part of the process is that at someone signs these things at City Hall, and then the way you prove you're married, for insurance purposes or whatever else, is that you have a marriage certificate.
Yes.
Right? So how can one of those things be fraudulent and the other thing be okay? Those two things being the marriage and the certificate of marriage.
Well, it's just like in Lewis versus Corbin, where the testatrix was convinced that she had signed a lawful codicil, but it was fraudulently done, and then there was the will that remained, but the codicil didn't, and that's why those claims sounded in tort, just as in here.
But the difference here is, let's assume the marriage certificate was signed by Joe Schmo.
Okay.
Okay? And John Doe goes to the ceremony and gets married. And that certificate is fraudulent. It wasn't signed by the appropriate party.
Yes.
That marriage between John Doe and the other person is not a lawful marriage.
I mean, I would say then that would be up for the court to decide whether it's
No.
lawful, but we're not challenging that.
Well, except for the next piece, which is if the marriage is not lawful, then your client gets the piece of the property. If it is a lawful marriage, she doesn't get a piece of the property. Correct?
Yes, that's correct.
So you have to say, back to my question,
Yeah.
the element that you would have to prove is that that is not a legal marriage.
I don't think so. I don't think that that's what I would need to prove there. I think that the decedent has that claim, or had that claim, or his estate may have that claim. But the claims that my client has are different than those. She didn't have standing to challenge the validity of the marriage.
So you're not challenging his capacity to get married?
I would say that the evidence, if we're allowed to, continue pursuing discovery, ultimately is going to reveal that he didn't have the capacity to get married and that he didn't even sign the application for the marriage license.
But does our case law say that you have to challenge someone's capacity to marry during their lifetime?
Well, this proceeded until the death, and the case law says that when this type of fraud is carried out until the time of the death, that it gives rise to a claim for tort.
In one sentence, can you tell me what the fraud is?
Yes. She obtained a marriage license and certificate and used it to get the statutory share when she didn't have a right to do that by means of undue influence. She used his incapacity at the time of his advanced age and just days before his death in order to, to pursue this for the purpose of getting a statutory share of his estate, which he had carefully prepared for ahead of time and made no changes leading into it. And my client had been frozen out.
Counsel, you used some very good language there for your side. It's not the legal certificate that gave her the marital share of the property. It was the marriage, the lawfully entered into marriage, that gave her the share, right? You could walk into that courtroom under this claim and say, this certificate is not legitimate, right? That doesn't get you to the, I want my share. You have to show that the marriage is not lawful. It's not the certificate. The certificate doesn't carry anything regarding undue influence.
Well, that would be the decedent's harm or claim, and this is a different harm to the plaintiff. The defendant's fraud was a wrong against the plaintiff and the decedent here, and a charge of undue influence may underlie a tort claim in addition to a trust or will contest.
Can I ask you? You talked about freezing her out. So we have in the record the transfer of the property with Kathleen and Hugh to the trust, but recorded right after that, Kathleen and her sister Colleen, for $1, transferred the property back to Hugh individually, right after the recording of the first deed. So in 2017, May 18th of 2017, this deed was recorded. He owned it. It was his to do what he wanted to in 2017. If he had, God forbid, dropped dead the next day, she wouldn't have a claim because it went completely back to Hugh. She had no interest in the property.
No, she would have had a claim if he passed away the next day after the deeding.
It depends what the estate plan said, but you say that somehow Mom froze her out, but frankly, they made a choice to transfer the property that had been transferred to the sisters from the sisters back to the dad.
Yeah, and I'm not sure that even my client ever understood how all of that worked. It was part of the overall estate planning. She was the personal...
It makes no sense.
I don't disagree. I wasn't part of the estate planning there. I can say that...
So she had a property right, and then like 2 minutes later, she gave that property right back to Dad.
That's exactly where our tortious interference with expectancy comes from, because at one time she did have a right into the property.
But I mean, it was for minutes, and it was before the mom moved back in with the dad. So how can it be tortious interference at that point?
Well, I think that the tortious interference happened later when Mom did move back in with Dad. And recall again that she had divorced him, and his support network at that time was my client and her sister. And all of the estate planning papers bear that out. She was his power of attorney, his healthcare proxy. She was the beneficiary, one of the beneficiaries of his will.
And that will was probated.
That will was rejected because the defendant came to court with a marriage certificate and elected for the statutory share, rejecting that will.
Can I ask you procedural about that? Not
Yes.
my forte. Couldn't your client have filed a motion to intervene in that action to say exactly what you're saying here?
She filed an objection. That's how you do it.
So,
Right. So again, this predates my representation of my client, but it was my understanding that she did, and she
lost.
Well, that happened later. But what happened earlier on was that she was told that there's no way for her to challenge the validity of the marriage unless she were to step into her deceased father's shoes and then raise that claim as him, which again, the harms against the decedent, which would be those harms, are different than the harms against my client, which is the tortious and malicious interference. And those claims can be heard by the Superior Court. They do sound in tort, and I think that, that we've plausibly articulated it above the speculative level at the 12B6 stage.
Mom filed a petition for formal probate, naming your client Kathleen as the PR, because that's what the will said, and your client chose not to take that role. And then there was a subsequent petition filed, and Mom, Frances, was named as the PR. Your client filed objections to the estate, and the objections after hearing were stricken. So any challenge to the estate, she made her challenge, and she lost. Did she appeal from that?
So it's my understanding that those were procedural and substantive grounds, and to the best of my understanding, that decision was made because she wouldn't have been able to challenge the validity of the marriage.
You can file a notice of appeal when an objection is struck pursuant to Rule 16. So she didn't challenge the and now a petition for complete settlement has been allowed and the final account has been rendered. So any challenge to the estate, your client waived if she didn't notice an appeal from it.
Right, well, and these claims are different than those that would have been raised over there. And
you keep saying that, and I keep trying to figure out how you keep saying it. If she had gone to the probate court and won, she doesn't just step into the shoes of the decedent. She gets her rightful share because she proves to the court the marriage was fraudulent.
That would be...
But she lost.
That's the decedent's claim, not her claim. The species of harm to my client is distinct from what would have been to the decedent.
It's the result that's the same.
Yeah, well, the harm is different.
But the result is the same.
Well,
again, the property was in his name,
But
right?
these tort claims derive from the harm received by my client, and that's what makes it different.
I see your time has expired. We'll take the rest of your arguments on your brief. And next we'll hear from Mr. Freeman.
Good morning, Your Honor. It's Brian Freeman on behalf of the appellee, Frances Flynn. We submit that this is a case that was correctly decided and dismissed on the 12B motion by the Superior Court on all of the grounds already noted during...
Can I pick apart one thing on that?
Please.
Judge Sarouf's finding on the undue influence, I'm not sure, I think it's on shaky grounds, because it's not that the allegation is that Frances caused him to, I guess, change his estate plan, which would be your typical. She didn't she collected under a statutory share, not under a document by which he was unduly influenced to do something different. Counsel says it's the marriage. Let's get past that. So could we still affirm the dismissal with prejudice on undue influence, but on the different ground that there is no evidence that he was influenced to do something different. That was not the natural object of his bounty, as our case law talks about.
Right. I mean, as you've noted, there was no disposition here
Right.
whatsoever. But I feel as though what Judge Saruf was saying is that all three counts went toward challenging the validity of the marriage, that none of them could be maintained without invalidating the marriage, which I think is everyone's gone through here. And I think that the complaint very clearly in all capacities, even if you look at the undue influence count, Justice Blake, paragraph, I believe it's 35, the last paragraph in count 1 says the marriage is invalid. I mean, so it's right in that count itself that he's challenging the marriage, saying that because of the undue influence, the marriage is invalid. So to me, I don't think anything needs to be clarified, but I do think that you're correct that undue influence can't stand under any facts where there's no disposition by Hugh Flynn.
Typically, we see a kid or a parent or a caretaker come in and say, change your will, they change their will, they die, you unduly influenced him to change his will. That's not the facts here. Your client takes because she is the wife at the time of death, and she takes pursuant to her statutory share. And if he's not challenging the validity of the marriage, which he has said today, then what's left?
Right. Well, I believe that I think it's very clear that the attempt to say that he's not challenging the marriage is just an attempt to try to survive dismissal on a dismissed case. Because when you read the complaint, it's a clear and unequivocal challenge to the marriage. One of the prayers for relief, as the court noted, was invalidate the marriage. It was also dissolve the deed of distribution, which she only got, that can only happen by invalidating the marriage. It was every time the marriage is referred to, it's so-called marriage, alleged marriage, purported marriage, invalid marriage. It went so far as to say my client calling it a valid marriage constituted actionable fraud. So the suggestion that the complaint doesn't challenge the marriage is just the appellant trying to reframe their own complaint to try to survive the dismissal. But when you look back at the complaint, Justice Saruf got it completely right. The complaint is an absolute attack on the marriage. And there's absolutely no ability to attack the marriage in the Superior Court, and the appellant has no standing to attack the marriage. And frankly, the appellant hasn't challenged those grounds. They've just tried to say, we aren't challenging it. But any rational reading of the complaint is that they are challenging it, and they're at a minimum attacking it. They're trying to say it's not valid. Collateral attack. And Bradford versus Parker said you can't collaterally attack a marriage. So there's absolutely no way it doesn't stand as a challenge to the marriage. So that's why we think Justice Saruf got it completely right.
Can I ask you about a date? The certificate of marriage says February 28, 2020. There are several places in the briefs that somehow list the date of marriage as March 1st.
I noted that in my own brief. I noted it to be February 28th. That's the date that the certificate said. I know the complaint, I believe, picked up March 1st, and I think that the Justice Saruf picked up March 1st from the complaint.
Did.
But from what my clients told me, what the certificate says is February 28th. I guess sorry, I didn't mean to cut you off.
Mr. Rourke's client get anything?
No, not in this situation, Your Honor, and that's because in this situation, the will is in 2016, and it's right before the divorce.
And the marriage, yeah.
So it's a premarital will, and in this particular situation, this was a 62-year relationship that got rekindled, and all 6 children are product of that marriage. And so in this particular case, because it's a premarital will and all descendants of the same marriage, the intestate share is the entire estate for my client.
That's what I thought.
Yeah. But we would just also submit, like, in addition to challenging the marriage, to have this action survive, it's challenging the decrees of the probate court, and you can't use a tort action to attack the decree. This has all been heard. The property's been disposed of. Like the court noted, they have failed to appeal. That's a final decree, and you can't let a tort action try to attack
the estate's closed, right?
The estate is closed.
Everything's been distributed.
It's been distributed, and there was, as you noted, an affidavit of objections filed. It was actually a lot of, if you looked at the affidavit of objections, it's like verbatim the complaint here. It's a lot of the exact same allegations. So this has been heard by the probate court where it should be heard. It's been rejected. It's been closed, and this matter is dismissed, and it should stay dismissed. So it should absolutely stay dismissed. There's absolutely no precedent that the appellant's given you to overturn this decision by Justice Saruf.
You still have more time, but I don't see any other questions from the panel. We're happy to take the rest of your argument on your brief.
That'd be fine, Your Honor. Thank you.
Okay, then this matter will be deemed submitted. You're giving us a lot to think about, counsel. Thank you both. That concludes today's sitting of this courtroom. I'd like to thank the court officers, court staff, and our wonderful clerks. And stay warm out there, everyone.
Thank you very much.
Court, all rise, please.